John, I'm going to pronounce it Potesta. Is that correct?
Yes, Your Honor.
All right, Mr. Potesta, you are going forward today without a court-appointed attorney. Is that correct?
Yes.
My understanding is you met with the prosecutor and you're pleading guilty to reckless driving for November 1, 2025. Is that correct?
Yes, Your Honor.
Do you understand your rights and the options those rights give you, sir?
I do.
And do you understand the possible penalty for the charge?
Somewhat.
Up to $500 fines plus court costs, up to 90 days in jail, and there's points from the Secretary of State when this conviction gets reported. I think it's 6 points. 6 points.
Yes, Your Honor. I'm aware of that.
All right. And understanding all of that, you're pleading guilty today freely and voluntarily. Is that correct?
I am.
All right. Tell me what happened on November 1, 2025 in Van Buren Township to make you think you were reckless driving.
I had my niece and nephew and my daughter. I was over at my wife's house. We're currently living apart. And I went over there to pick them up, and the kids wanted to take a ride in the back of my truck, which the year before we did, but it was up in the country. And it's the first thing they asked me about. And just made a really poor choice. And I did it. I took them out there and I drove around the neighborhood with them. And I got pulled over with them in the back of the truck. And yeah, we all got questioned, and it was a pretty bad experience for everybody.
How old are the kids?
My daughter is 13. My niece and nephew are 9, 10, and 12.
Okay.
So pretty young. I mean, yeah, I don't really have a good excuse for any of it. I had him in the back of the truck, and we were having they were having fun. I didn't.
Yeah.
It was a stupid thing to do. So
were you going over the speed limit?
I don't recall how fast I was going. I think I was right. I can't, the roads there are potholes and there's a lot of turns.
Right.
So I was going over probably, I don't recall how fast, but I wasn't ever trying to put them in any danger.
Right. All right. Give me just a second, sir.
Okay. Thank you.
Potesta, P-O-T. All right, Mr. Potesta.
Yes, Your Honor.
I sense that you're just really feeling guilty and want to get this over with.
Yes. Yes.
So here's my problem. I don't find that to be reckless driving. I'm old enough that in my day, we used to haul kids around in the back of pickup trucks all the time. So, I mean, if you were on 94 doing 70 miles an hour with them in the back of the pickup truck, or if you were in the neighborhood going 55 miles an hour on 25-mile-an-hour streets with them in the back of the pickup truck, maybe I could find reckless, but I'm not seeing it. So I'm going to ask one of the attorneys, one of the court-appointed attorneys, to get on Zoom and talk to you about this and just figure out how we can resolve this, because I'm not comfortable taking a guilty plea with that factual basis. Just as if, for example, you were charged with drinking and driving and wanted to plead guilty because you wanted to get it over with, but you told me you weren't drinking and you weren't driving. The facts aren't there to support the plea. Understand?
Yes, I understand, Your Honor.
All right. So hopefully we're gonna get this resolved for you today, but just bear with me a little bit.
Okay. Thank you, Your Honor.
You're welcome.
Miss Odette?
Yes, Your Honor. I'm not sure what the court would like to do in the Carl matter. He was on the delayed sentence. There have been some violations allegedly of that delay. I don't know if you want to just address the victim for his sentencing, or if you'd like to. I guess it's up to the court.
Sure. I would have thought I'd do is we could. It's gonna be, if there's a violation, I guess I could do it either way. What, Ms. Odette, are you comfortable going through it today, or do you need a new date? And I can consider a bond?
It's up to you. I have to walk in to this appointment in 3 minutes. So
All right, I'll tell you what, he's out on bond, isn't he, right now? Why don't we do
he
a
is, but
bond review right now? And then if I
okay,
find it, if one way or the other, we'll set it for a new date for sentencing.
okay. Thank you,
How's
Your Honor.
That'll get you out of there. All right. Are you going to stand for a minute, or are you just going to leave it up to me?
I spoke with
Yeah,
the victim,
okay,
and I think she's comfortable addressing the court
okay.
and has some verification of the bond
Okay,
violations with her.
if some reason I run into a hang up, we'll reschedule it or something, but we'll do a bond violation hearing today and see what we got.
I appreciate that, Your Honor. And
All right.
I apologize.
That's
It
okay.
was,
Things happen. They all get crammed into one day. Yeah.
thank you,
Yeah,
Your Honor.
All right, thanks.
Okay.
Those two. Gerard Carl, maybe we can do that one. While we waiting. There's scheduled for sentencing today, but our prosecutor had to leave for another appointment, as well as there's some allegations for bond violation, another set of bond violations. So I told Mr. Berlanga that I would proceed today with the addressing the bond conditions first, and then I told Ms. Odette that I would set for another sentencing date. Mr. Berlanga, I don't know if you've had a chance to kind of review whatever.
I have, Your Honor. So with regards to this case, I've had a long conversation with Mr. Carl about his bond conditions, no contact order, and third-party contact. Essentially, what it boils down to, I think, Ms. Cheyenne Carl. Okay, Cheyenne Carl is some text messages that are from a third party who is believed to be Mr. Carl's current girlfriend. It's not current contact from Mr. Carl himself, to my understanding. However, that's the situation. Mr. Carl is actually going to move to a different residence, so he doesn't live with his current girlfriend, and I don't know what's the status of their relationship. But nonetheless, he is very well aware that his girlfriend can get him in trouble as well as far as the case goes, but he's not directing her to make this, contact. He's not telling his girlfriend she's got to do this. So as far as the bond violation or any potential bond violation, the defense position is that he doesn't have control over what his girlfriend does, and he's not directing her to do anything. But nonetheless, it's still a situation that he can diffuse, and he wants to move away from that. So my understanding, he has support here in the courtroom, family, friends. They actually own a rental property. I was going to provide the courtroom address because he's currently untethered, but he's tethered to that residence, so he can't leave that residence where his current lives.
Okay. Mr. Berlanga, just for your sake too, when I open up file, is this something I'm supposed to see, or
That
what?
was stapled to the front of the file.
Oh, okay.
I kind of came loose, but it's
Okay.
just from the past bond
Yeah,
violation.
okay. All right, so that one I'm just gonna restaple on there, just so I know what I'm dealing with. Ms. Carl, why don't you come up to that podium for me there for a minute? And why don't you do this for me? Raise your right hand. Do you swear from the testimony you're about to give will be the truth? Okay. I guess let me kind of help everybody guide through the first violation we found was September 11th of 2025. I found a bond violation on that date. Are you alleging that there's something beyond that date now?
Yes, the last time we were in court, you told Mr. Carl that there would be no third-party contact. Whether Mr. Carl knows it or not, his current girlfriend, Mrs. Hilliger, has not stopped. I have a room that I really don't know if you want to see, and Mr. Carl can't tell me he doesn't know Mrs. Hilliker was taking the photo of them behind closed doors. He was looking right into the camera. Whether it's old, new, I don't know, but it was sent to me recently. I'm taking it, Mr. Caro has mentioned to Mrs. Hilliker that we sometimes run into each other at the gas station, because on my way to work is the gas station that his employment is right next to. Mrs. Hilliker had mentioned for me to be there at 8 o'clock in the morning, so she can, sorry to be blunt, but whoop my ass.
Okay,
My response was, I'm sure his boss would love to know that you're trying to fight at a business.
when was that? Is there a date mark on there?
It just says Friday. There's not an actual, like, say October.
When did, and you're telling me you received that sometime recently?
I know less than probably 2 weeks ago, I ran into Jared. Jared and I did not say a word to each other. We didn't cross eye contact, nothing. But it was probably about 2 weeks ago when I pulled in to get some drinks for work, and he was coming out of the gas station going to his tow truck and filling it up.
Okay, so how did you get, where'd this come from then?
Mrs. Hilliker's phone. She texted me off of her regular phone number.
Oh, I see, and this is a screenshot of your phone.
Yeah, it's screenshotted and I printed it out.
In that one, you're telling me you got about a couple weeks ago?
Yeah.
So it's well beyond the
Well
September,
beyond since our last.
September 11th?
I also have 2 video messages from Mrs. Hilliker to where she said that she was going to do me again, whoop my ass, whether I have my kids with me or not.
Okay.
And the most recent one I have is to watch my kids because she's going to knock them down to ear size. And I have that in voice recording. I would be more than happy to play that for you. I'm sorry if the language you're gonna hear.
Okay, the problem, which is what Mr. Berlanga is gonna argue for me, is that it sounds like it's just her
It
talking.
is her. I can say it's not Mr. Carl, it is his girlfriend. But I don't believe that Mr. Carl does not know she's doing this. Like I said, the photo that was sent to me, he's looking right into the camera, like he knows she's taking the photo. Whether it's for their own personal use, whatever, but it got sent to me, making me thinking I'm going to be jealous or something, 'cause I'm not.
And that one was sent again a couple weeks ago?
This one was sent. Today's the 25th, this was sent November 15th.
Mr. Berlanga, and you've seen these, have you?
I haven't seen the November 15th.
Okay.
Because Mr. Carl, whatever they're doing,
Was that sent to you?
that was sent to me from Mrs. Hilliker's phone.
Same kind of thing. Yeah, I know the argument's gonna be, do you mind if I view that
No.
picture? Okay, ma'am, why don't you just bring it, let me just see the picture. Let's see what you got. Oh, I see, okay. Okay. Okay, so, I'm not trying to cut you off. Is that cover it with the, Situation
I
is-
edited a lot of that out, yes.
yeah. But is it all the same type of thing where it's her actions,
Her
whatever it's going?
actions, yes.
Yeah.
And you can see from, when I had seen it, from her belly button all the way down to what you just seen of Mr. Carl with his cup out.
Yeah, okay. Okay, why don't you have a seat for just a minute? Let me, let Mr. Berlanga help me out a little bit. Again, this is just strictly in the bond.
Yes, Your Honor,
Situation.
so, as I stated, I've gone over everything in regards to the information. I think Ryan Carl and Ms. Carl even says that Mr. Carl is not doing anything. They even had an interaction where they completely handled it like they're supposed to as far as legal terms, walking past each other, leaving the area. Mr. Carl is handling his part of that. As far as separating himself and, you know, they could have maybe had a conversation we had between him and his current girlfriend about what kind of contacts and she could be involved in regards to something like this could take
Yeah.
on. But nonetheless, right, he does want to resign in a different place so that they aren't necessarily living together and kind of separate, then they get a conversation. And I think that's something he can do outside of the court. But nonetheless, it seems like third-party contact that saying that Mr. Carl was not directing, it's just he can't control it.
Okay, and you're telling me that he's moving from whatever
Yeah, where are you looking
residence?
at? Closer to.
Miss Leonard? How do you know Miss Leonard?
I started working for her son-in-law about 8 years ago, and I've got to know the girl and known them very well.
Oh, I
over
see.
8 years, and I reached out to them so that way I had some sort of support with me through this, because this is my first time ever getting in any sort of trouble, so I'm kind of lost and just needed help.
Well, the big problem I've got is this, apparently your girlfriend, what's her name? Jennifer, what's her last name? Oh yeah, I did have Helker on here, yeah. What, in fact, I've got her full name, I guess. What, this, I know I'm not gonna beat it to death, but Mr. Berlanga, she's causing some issues, period. And it's really easy for me to say, listen, it's your girlfriend, your picture's on there, it's gotten sent, this is the second time I've been through a bond violation. It's really easy for me just to say, you know what, it's just tether gets removed and you go to jail till we get this thing sentence over. And I'm not saying that you're doing it. I'm not going to, I'm going to go through Mr. Berlanga for that. But it all points to you. It's just getting to be you. It's who you hang out with or whatever's going on. Something not right. I appreciate you moving. How are we going to correct this, though? You help me out. You tell me how are we going to... Are you still seeing her?
I'm currently still communicating with her, but I'm doing my best to try to get away because of the situation that's going on.
Yeah.
I'm really just trying to do everything I can to do right.
Did you break up with her? Because I'm not going to force that, but...
No, but we definitely need to have a conversation about what's going on as far as third-party contact.
I'm sorry, so are you living at her place right now? You're going to move?
Yes, I am.
When are you moving? Just looking at Miss Leonard. What? Now you're gonna drag Miss Leonard into it too. What? Miss Leonard, is he moving into one of your rental?
Within 3 miles of my home, Your Honor.
Okay,
And he did previously rent from me for over 5 years.
Okay.
Great tenant, never paid late.
okay,
And then he bought his grandmother's home, still in Montrose.
okay,
And then that didn't work out. So he wants to get back to Montrose. He does good there. He can go to church with me there. He can get counseling from the pastor there. His work's there. But part of his order, unless he read it wrong, he couldn't move.
right. He's tethered to that. I don't know if I had a specific place, he just had to be tethered.
Yeah, it was listed on his thing, but that's, so I told him we were gonna file a motion to come before you to ask that he move, but because he had this, we thought we'd just ask when he was here.
Yeah,
But I came so that I can vouch for him that, yes, he's moving there,
okay,
and, yes, living within 3 miles of us, and my husband and I are willing to help him because I'm just afraid he's one of these people on the border. And
Yeah.
at this point, we can come up, or he can drop real quick, and I'd like to see him come up.
yeah. And I've been, Miss Leonard's always been upfront with me with tenants and I guess family members too, if I remember right. Miss Carl, where are you? Are you in Montrose?
I'm on the borderline of Montrose and Bird, so actually I live less than 5 miles from Mrs. Leonard also.
Okay.
Yeah, I live on UG Street, and that's in between Bird and Birch Run Road.
let me, I guess, given the situation that I'm hearing with the, quite frankly, the girlfriend, Ms. Hilliger, if Mr. Carl moves back that way, is that going to be an issue?
If Mr. Carl can actually move to Montrose and
Behave?
continue to better his life, then I'm all for it. I'm not out against it.
Yeah,
I'm ready for this to be done and over with, but
yeah,
unfortunately, the people he's around
Yeah.
are only gonna keep bringing him down.
yeah,
I would love for him to be a father to his kids and everything, but because of his current girlfriend, it's not possible.
yeah. And so whether you are getting along with her or not, she's been honestly pretty good about this whole, really, whole thing. And Miss Leonard is, you got two ladies that are looking out for you, quite frankly. One of them's the victim in this matter. But you've got to prove to me that I can trust that this is going to happen. If that girlfriend comes back, and whether you moved or not, again, it's going to point fingers at you. How long have you seen Jennifer Hilker?
Almost a year now.
Okay. Do you have kids with her or anything?
No.
Just a girlfriend?
Yeah.
You know, given what I've got here, I guess it's a little unusual for me to do this because I don't want to get into that relationship, but I'll tell you what. If I order conditions all stay the same, the move is fine. But part of this is going to be no contact with Jennifer Hilliker because it's causing issues right now. If I make that part of this bond condition, at least I can feel like, you know what, whatever she's doing right now is what she's doing. Does that make sense?
Yeah.
Mr. Berlinger, anything if I do it that way?
Your Honor, I would refer to the discretion of the court. I don't know as far as her involvement in this case.
Yeah.
It's basically stemming from a alleged bond violation, so I don't know.
Yeah, and I'm not holding the bond, and quite frankly, the bond violation's not gonna be there, but it's just, I'll handle controlling the situation right now.
I understand, and I guess I would defer to the court as far as the court.
You got any other ideas?
So I'm just trying to better myself. I'm trying to get help and everything else. I got a great support system behind me now. I just want to do better for my kids, for myself.
How are we gonna address the Jennifer Hilliker situation?
That's the biggest thing. I just gotta figure out.
Planning on moving into that house that way I can get away.
To make this easier, Judge ordered a no contact order with the facility where you cannot actually have contact with her, similar to the one you have with Carl.
And it's hard for me to like completely because Jennifer picked me up when I was at my absolute bottom and had nothing.
Yeah, no, I understand.
You know, I need to be able to try to communicate with her so that she can understand the importance of this no contact person because it is at the end of the day falling back on me.
I guess I can do it two ways. I'll give you right up front. And again, I gotta, Mr. Berlinger knows too. I have to find evidence, but if she makes another contact, guess who's, I'm pointing at you, period, at this point. And if you're gonna come back and tell me, well, I'm still having which is, that's your doing. Yeah, I'm still having contact with her. You gotta understand, I'm in a predicament where it's like, I told you, and no matter what that is, however that's working, it's not working out so well. I could very well, without arguments from anybody, is say, listen, there's still a violation, rightly or wrongly. Mr. Berlinger?
Judge, I was gonna say, and I think the court's kind of leaning this way, from my understanding, but I would say a zero tolerance as far as any contact from Jennifer Hilliker would also fall back on Mr. Carr.
Yeah.
And so he should be Ms. Hilliker about what's going on in
Yeah. Yep, and why don't we do it this way then? I'm gonna leave that decision up to you whether there's contact or not. But listen to what your attorney and what I'm telling you too, it's unfortunate, but Ms. Hilliker's getting herself into a jam now too, beyond you, okay? So if you come back and tell me there's been no contact, that's fine. If there's been contact but no incidents, that's okay too, but Ms. Carl?
Can I play a video for Mr. Carl? Since he thinks that Ms. Hilliker is a great person that picked him up. I have a voice recording of Mrs. Hilliker threatening to take him and mine and Mr. Carl's kids out. What kind of great person is that?
Yeah. Maybe, if you, if Mr. Berlanga wants him to hear that outside here, that's fine. Maybe that's a good thing to hear, all the way around.
I'll have a conversation.
Yeah, yeah. Okay, so I'm gonna leave it up to you, knowing full well that that's you're balancing on a tightrope that it's an issue, okay? All right, so we'll, with the bond, yes,
I'm just gonna give it for it.
I'm sorry, what is it?
Oh, I'm writing on the bail bond issue.
Oh, yeah,
That's where it's moved to?
Yeah. So, Ms. Carl, for your sake, and I'm not doubting what's going on, but I'm just gonna dismiss the bond violation. You're moving and, keep all those things though, okay?
I'll put that out to get Mr. Carl. I
Yeah.
have the greatest phone, I really do.
Yeah,
Could you tell Mr. Carl, even though there's a no contact order between him and I, he can still have contact with his kids?
yeah, sir, if that isn't clear, it's just no contact with her. You know what I mean? If there's a third party or something, yeah,
I know we can't directly talk to each other.
it's okay, you're in here, right? Go
Okay.
ahead, go
You
ahead.
can get a hold of Kristen because both of our kids have their own phones for their own numbers. I don't have their number.
Do you want to, Ms. Brilliant, maybe you can kind of intervene, just, we don't have to do it in court here, but,
Whatsoever.
okay,
I will reach out to my sister that you made the middleman.
I remember, yep.
I will have her give Mr. Carl her son and daughter's number.
okay. Let's do that, one way or the other, you gotta work through this part, and I'm trusting both of you want to get through this for your kids too, and it sounds like you do, and I'm assuming you
I know he
do,
wants to be part. It's been a year.
yeah.
It's been
Yeah.
a year since he's seen or talked to his kids.
Okay, so I'm just dismissing the bond violation. We'll set sentence date for, let's give it a few weeks to see how things are going. Let's get through, actually, gosh, we're coming right into the holiday. Let's get it beyond the holiday just to do that. Set a sentence date for like January.
Figure out a date since we're changing
Yeah,
our schedule around there in January.
guess at one, we can always change. Yeah.
I'll keep it on the list. January 7th, but we'll be.
Okay, January 7th. Yeah, 8:30. It's call for you too, and it'll be on Zoom unless obviously we run into issues again, but, okay? So we'll do January 7th, everything's still in place, okay? You get a lot of people trying to help you out, but at some point I'm gonna have to make some not very kind decisions if we have to, okay? Okay. All right, and listen to what Ms. Leonard says. I know she's got a good sense of things like this too, okay? All right. All right, we'll do that. Thank you. Ms. Carroll, thank you. And why don't you follow him out, I guess, Mr. Berlanga, you're gonna, yeah. Okay, all right.
All right, we'll go on the record in State of Kansas versus Hope Row, case number 20 CR 107. Would counsel announce appearances, please?
May it please the court, the state appears by Jill Gillette, County Attorney.
May it please the court, Mary Ann Shirley on behalf of Miss Rowe.
All right, this is set for a hearing on a warrant to show cause. Mr. Catley, are you appearing on this case as her ISO?
I am, Your Honor.
All right, Ms. Shirley, what announcement is being made today?
Your Honor, my client would stipulate to the violation. There are some mitigating factors and issues. We would hope, it appears that she served 155 days now. She has a 17-month control sentence. Basically, she is a battered woman. And what happened last time, we were hoping to have her in a treatment program before her husband found her. That did not happen. Consequently, she couldn't get away. We have found at the time she was Senate Bill 123 that original placement has expired now. I did, however, locate a facility with a bed that can take her if SAC has agreed to come over on Monday, if we can come up with $75 to pay them. Then I have found her a placement at Community Health Center in Crawford County, their addiction treatment facility. If she qualifies, she can do that on furlough. And then they have a program available for Oxford House after that. Miss Rowe is 26 years old. She has no family in the area. She has no marketable education or skills. But if we can get her through a treatment program, develop her self-esteem, get her away from, hopefully we can get her a divorce before he finds out where she is. And it's my understanding he's in Sedgwick County Jail, so we'll be able to get service on him without hunting him down. Hopefully, Your Honor, if you would be kind enough to give her the opportunity to comply with your original orders, if we can get her away and in a placement, this young lady has a chance. And I think that it would be beneficial to her to do the treatment in the Oxford House. And as I said, she understands that if she's on furlough, that if she runs away or disappears or does not comply with anything, that it would be considered a felony escape from custody, and it would be a lot more than 17-month sentence.
All right, so she was previously ordered, was it back in October of 2024?
I believe so.
It was October 9th was our last revocation on her.
Okay, but that was 2024, not last month.
Yes.
Okay. All right, Miss Rowe, your attorneys announced that you wish to waive your right to an evidentiary hearing and stipulate that you violated your probation as alleged in the warrant to show cause. Is that correct?
Yes, sir.
Do you understand that you are entitled to have a hearing? At that hearing, the state would be required to show evidence or to try to prove by preponderance of the evidence that you did violate your probation. Do you understand you have that right?
Yes, sir.
Do you understand that by admitting to the violations, I will find that you violated your probation?
Yes, sir.
And do you understand that you could be looking at serving an additional jail sanction, or at this stage, you could be looking at having your probation revoked and being ordered to serve your underlying sentence?
Yes, sir.
Has anybody made any promises or threats other than any agreements you may have with the state
No, sir.
to waive your right to this hearing?
Do what? I'm sorry.
I think you answered before I was done making my.
Oh, sorry.
Nobody's made any threats or promises to get you to enter this stipulation and waive your right to a hearing?
No, sir.
So you agree? I'm just going to read from the warrant to show cause. It alleges that you were to contact your ISO every Monday until you were able to get into sober living. The last contact with the defendant was November 20th, 2024. A violation notice was sent to the defendant's last known address, instructing her to report on December 30th, 2024. The defendant failed to report and her current whereabouts are unknown. Do you agree with that?
Yes, sir.
Then it also alleges that you failed to re-engage in Senate Bill 123 treatment as directed. Do you agree with that?
Yes, sir.
All right, I'll find that you've made a knowing and voluntary waiver of hearing and admitted to the two violations set forth in the warrant to show cause. I will find that you have violated your probation. I've heard Miss Shirley's recommendation as to how she wishes the court to proceed. Miss Gillette, what are your recommendations for disposition?
Your Honor, unfortunately, throughout this entire case, this has been the same thing. Miss Hope Rowe has had the opportunity to do treatment, to get into things, to help herself. Her ISOs have offered help. Different people have offered help. She does not engage in it. I was trying to look through her list of hearings. She came to 2 hearings, not in custody, in the very beginning of the case. She took off on us in February of 21. She did not come to her hearing March 18th of 21. She called our office. She was told to turn herself in to the sheriff. She wanted me to undo the warrant. In June, there was still no defendant on her bond forfeiture date. She was picked up and released from jail, and September 29th, she disappeared on us again. Then she remained in custody until her case was done. And then she ended up taking off on her probation. She was sentenced on, her sentencing was February 2nd of 23. She ended up taking off on us and in June, and we had no contact with her after that. She didn't do her Senate Bill 123. If she would reach out to the CSOs while on corrections, they have all kinds of resources to help individuals and get them into treatment. We had her first revocation. We sanctioned her. She was in for 43 days. And then she ended up having her probation extended, had a 48-hour dip. She stipulated and waived her hearing then and promised that she was going to go into a treatment right away. That did not happen. So her hearing was October 9th, and by November 20th, she was gone again. And while I feel for her having these issues with a spouse, the problem is she doesn't engage with her CSOs and her ISOs in this case. She doesn't engage, and therefore they can't help her. She has shown that all she wants to do is take off and that she's not amenable to probation and is being intentionally non-compliant. Even if she's on the run, she can call, she can stop by, she can come to her meetings. They can help her get into an inpatient treatment facility. My office can keep her address that we use confidential. But none of these are utilized, none of it. So I believe she's just intentionally being non-compliant, and she's not doing anything to even reach out to her ISOs for help, nor the court, and she just takes off on us every time. Once she comes into jail, we offer her mental health treatment, get her back on the right course of action, but she isn't utilizing any of the resources. She literally absconds every time from the court and from the ISO.
So what's your recommendation?
My recommendation is intentional non-compliance with Senate Bill 123 and absconding. This is more than just a condition violation, and that she should serve her underlying.
All right, thank you, Ms. Gillette. Mr. Ketley, how would you assess Ms. Rowe's position on probation?
Well, I haven't hardly seen her. I mean, she does take off like Miss Gillette reports. I mean, I don't know of all the, like, Miss Shirley talked about all the spousal stuff going on. I'm not aware of any of that other than what I'm sure that what Miss Rhodes spoke with Miss Shirley about. But she does not report. I know that.
And Senate Bill 123 is already expired.
Yes, it has expired.
Have there been payments made on the case or any effort at all?
I don't believe so.
Mm-mm.
All right. Anything else you would add?
No, Your Honor.
All right. Miss Shirley, anything additional by way of recommendations?
Nothing other than she's young and she has no resources of her own. She basically was under the control of this man who kept her basically isolated and locked in a hotel room. She has never received the treatment she needs. We would ask the court to give her that opportunity. As I indicated, if we furlough her to the program, she doesn't have any options, and she will have resources there to help her accomplish and learn the skills that she needs that Miss Gillette has recommended. Probably, well, there are some things available and in Topeka. Some of my clients have done remarkable things with their programs. But Miss Rowe has not been able to take advantage of the things that Miss Gillette stated. And by doing it through the Community Health Center in Crawford County and the Oxford House, I've seen wonderful results there. And the allegations that she's intentionally done these things. In this particular case, Your Honor, my experience with her, that is not the case. She basically had no control over her own life and didn't have a phone of her own, had to rely upon Mr. Nathan Smith for everything. Would ask the court's indulgence one more time. Thank you.
Thank you, Miss Shirley. Miss Rowe, is there anything that you would like to say at this time?
No.
All right. The court's familiar with the history of this case. The sentencing was back on February 2nd, 2023. And there hasn't been anything accomplished on probation. Miss Rowe, you were given the opportunity for Senate Bill 123 treatment, which hasn't been accomplished, and that's expired. The court gave you an opportunity last year, back in October, basically to accomplish what you're asking the court to do this time. And then you disappeared and quit reporting. I understand you may have some issues with this boyfriend or spouse, and that's unfortunate. But the resources that you seek have been available this whole time you've been on probation through your ISO. Had you stayed in contact with Mr. Ketley, you would have been able to complete all of these programs and be done. You should have been off of probation long ago. And frankly, it's just not a successful probation, and I don't see wasting any more time trying for you to be successful on probation when you just haven't made the effort to do so. So I'm going to have the probation revoked, and I'm going to order that you serve the balance of your underlying 17 months minus any credit that you've already accumulated. You do have 20%, are eligible for 20% good time credit, and have 12 months post-release supervision. Ms. Shirley, are you appointed or retained?
I'm appointed, Your Honor.
All right. I'm going to, pursuant to State versus Robinson, I'm going to waive court-appointed attorney's fees based on Ms. Rowe's incarceration and future incarceration and inability to pay those fees back. Anything else from the state's perspective, Ms. Gillette?
No, Your Honor.
And Ms. Shirley?
Nothing. Thank you, Your Honor.
All right. We'll be in recess. Ms. Rowe is excused at this time. Thank you. All right, we'll go on the record. Case is entitled State of Kansas versus Joe Cheever, case number 24 CR 15. Would counsel announce appearances, please?
May it please the court, the state appears by Jill Gillette, County Attorney.
May it please the court, the defendant, Mr. Cheever, appears from the Greenwood County Courthouse with counsel Christopher Ambrose of Harbus Legal.
We were last before the court on August 14th. At that time, Mr. Cheever entered a no contest plea to a felony theft charge. Sentencing was scheduled for today. I have received a pre-sentence investigation report indicating a criminal history score of C. Ms. Gillette, any objection to the criminal history score?
No objection, Your Honor.
And Mr. Ambrose?
No objection, Judge. I went over that with my client before we came on the record today, and appears accurate.
All right, Mr. Cheever, you've looked over the criminal history and the PSI. But you'll need to answer audibly.
Yes, sir.
All right, and you're not objecting to the criminal history score of C?
No.
All right, I will establish criminal history score of C. Ms. Gillette, are you aware of any legal reason why the court should not proceed to sentencing at this time?
I am not, and there is a victim here who wants to speak.
All right, is that Mr. Hanson?
It is.
Okay. Mr. Ambrose, any legal reason why we should not proceed to sentencing today?
No, Your Honor.
All right, also appearing is Tony Bauer from Court Services, who prepared the PSI, as well as Christy Ashenfelter with Community Corrections. All right, this case is presumptive probation. It looks like it's possible Senate Bill 123. Is that correct?
Yes, Your Honor. I think it's going to be 123 plus, technically.
All right, Ms. Gillette, I would take sentencing recommendations at this time.
Your Honor, this is a theft of property or services, obtaining unauthorized possession of a boat motor. The defendant falls into a presumptive probation box, and we would recommend the standard term of 12 months, up to 20% good time credit. There is a 12-month post-release supervision in mandatory drug treatment. His probation duration is up to 18 months with the mandatory Senate Bill 123. He does not have any jail credit days. The conditions of supervision are set out on page enumerated 5. He has scored out for community corrections. He needs to follow all conditions of probation, including MRT program and Senate Bill 123 plus program. The defendant should have no contact with the victim. He should not be on the grounds. It is the old schoolhouse in Severy. He should not be anywhere on that property. He needs to avoid that area. There is court cost, a DNA database fee, but I thought his DNA was already on file. Community corrections fee and correctional supervision fee, booking fee, the Senate Bill 123 plus reimbursement fees. What the court needs to inquire pursuant to Robinson of bids, attorneys, and bids application fee. This is one of those hard situations. There are numerous items missing from those buildings. The boat motor that was what he was seen helping take from the building, that was recovered. But there are numerous items that were not recovered. And so I know that the victim is wanting restitution on some of the other items that were taken. But the only item we have Mr. Cheever helping remove and put back is the boat motor. He was the driver and then he went and recovered the boat motor when it was asked for. There were also some other items that were recovered that had been sold, such as air conditioners and lawnmowers. He does have, at the time that he was convicted, 22 CR 62 in Elk County. I don't know if he has completed that case or not, but this case needs to be consecutive to that case, whether it's been completed or not.
Ms. Gillette, there's no special rule listed in the PSI.
He was on supervision in 22 CR 62, I believe.
Your Honor,
Yes.
there's not a special rule that applies to that because that supervision was a misdemeanor supervision and not a felony. He was on supervision at the time, but since it was a misdemeanor, it does not kick in the special rule for being on a felony probation.
All right, but Ms. Gillette, your request is that this case run consecutive to that case?
Yes.
All right, go ahead.
And the victim is here and he wants to speak. I ask the court to allow Mr. Hansen to speak.
Okay, so is there a restitution request?
Judge, we did not agree on a restitution request because again, what we have Mr. Cheever participating in was he was on video, helping drive. It was his vehicle that they used to take the boat motor in. The boat motor was recovered, but the school had been broken into several times. And again, I can't say who took all the other items, but I do know that he was involved in the boat motor by driving.
Are there co-defendants?
There are 2 co-defendants in these cases that were involved with the boat motor. Mr. Evans and his girlfriend, they are already on supervision. They are in the Iola, Kansas area and are reporting as a courtesy supervision there.
All right, is there a request being made that there be no contact with those individuals?
I don't think they're having any contact, but yes, they should not have contact with each other.
All right, anything further, Ms. Gillette?
I can't think of anything else.
All right, Mr. Ambrose, your recommendations?
Ask the court to go with the presumptive sentence on this case, sentence Mr. Cheever to the standard 12-month underlying sentence, place him on probation for a period of 18 months, allow him to utilize the Senate Bill 123 treatment or 123 plus treatment. We don't have any objection to the issue of this running consecutive to that previous case. My understanding is that case is completed. Would note for the court that Mr. Cheever is on SSDI and has limited assets as a result of that. Spoke with him about kind of where he's at the end of the month. And he indicated that if he's breaking, at best he's breaking even. My attorney's fees in this case are going to be about $1,400 by the time we're done. And I don't believe Mr. Cheever has any objection to that no contact order continuing while he's on supervision.
All right, anything further, Mr. Ambrose?
I don't believe so, Judge.
All right, present on the meeting is Daniel Hansen, who is the victim in the case. Do you wish to address the court, Mr. Hansen?
Yes, I do.
You may do so at this time. If you could start just by stating your name and then you can provide your statement.
Daniel Hansen. I want to ask, what does presumptive probation mean?
Presumptive probation means there's a sentencing grid in the state of Kansas where a defendant is placed on a grid based on their prior criminal history and the level of the offense. The level of this offense and the defendant's criminal history falls within a presumptive probation category.
Okay. All right. Well, then I'd like to start out by saying what I found out is that it wasn't multiple times that they were burglarizing my school. It was over a 3-day period. And it was a 3-day period. The people involved, I understood, were Jody Cheever, Bert Evans, his girlfriend, and Kim Higbee. The items they took amount to about $25,821. They took my Husqvarna zero-turn lawnmower, my Husqvarna walk-behind trimmer, my Husqvarna walk-behind mower, the DeWalt drill press, the DeWalt table saw, the ESAP MIG welder, the ESAP plasma cutter model 2000. They took 3 Lincoln stick welders. They took my Lincoln 220 MIG welder, which I had just brought back from Colorado, a box of wrenches with Snap-on and Wright tools in it, tool spools of 3/0 copper wire. I had 4. I have 1. I had 3. I have 1 left. They took tool spools of brand new 3/0 copper wire I needed for a project. And they now price at about $5,000 for the 2 spools. They took, they damaged the main copper water pipe in the school. I don't know if they were trying to steal the copper, but they damaged it. They took 1 commercial microwave. They took 2 Frigidaire 15,000 BTU window air conditioning units, 1 high pressure cat injection pump. It's not worth $10. The other items are worth, well, $900, $3,500, $3,000, $1,049, $800. They took the Suzuki outboard mower motor. They took a box of brass fittings. The total came out to $25,821. Some of these values are the prices that I paid when I bought them used. Some of them are the prices that would cost me for the items that I bought new. So not everything is a value of something that was new. A lot of items like the DeWalt drill press I have down at $400. The DeWalt table saw I have at $400. The ESAP MIG welder is $3,500. I bought that new 10 years ago. To replace it would be $3,500. When this happened, I was in Texas. A neighbor called me, say, hey, there's people in your school. There's this man with a van and these people hauling off wire. They were hauling off wires, what she saw at that time. She didn't see the boat motor. So then the deputy, Mr. Myers, went to the school. Doors were open. In addition to what they took, they got into the office at the school and they took the keys. They took the keys to the buildings, the keys to the vehicles. They took the keys to the van, to the car. I don't have the keys. I have 3 vehicles. I can't move. And I had to go back and put hidden clasp locks welded on the doors in the school because they had the keys to the actual locks to the doors. For me to go back and change those commercial locks, I don't know if that's $200 a piece. I don't know if that's $300 a piece, but there's got to be 10 different doors around that school. Somebody told somebody that told somebody else that told me, hey, one of your conditioners is in this guy's window, 2 blocks from my school. So I drive by and I look, and that's my window unit. So Mr. Myers comes the next day and we go over, we look at, the guy admits, he says, okay, yeah, this must be yours. I just bought it from Jody Cheever. So he gets my window unit out. We're loading that back into my van. The man's not charged for receiving stolen goods. And we're standing there looking across the street, and the other guy across the street is mowing his yard with my mower. So and this is just a couple of blocks from Jody Cheever's house, but it's like 25% of this town is a subculture of their involvement in theft. And I've been burglarized before. I've had vandalism before. I get approached by Mila Whitaker at the post office, who is Kim Higbee's sister, who says that Kim and Jody probably did me a favor because I was insured and I'll make money off the burglary. I have no insurance for theft. And she said, in addition to that, is I probably deserve to get robbed because I had nice things at the school. This is this culture of people there that just believe that somebody owes them a living. Now, I've asked, I asked a couple of deputies, and they said, you know, maybe they get sentenced to 3 years and they do a year and they get probation. It's not enough. It's not enough. I mean, in addition to that, Bert Evans, he got probation, but I don't understand that he wasn't obligated to repay the damages, any of the damages. I would ask that Jody Cheever, and he's on SSI, I don't know what he has or how he can pay me back, but it should be part of his probation that he's got to pay me something every month. And it's probably going to be forever because of how much money they took, how many, you know, the value of the items they took. I can't get past what I hear from people in Severy and how they see the world. And Jody Cheever is a part of it. If you give him a short sentence, he's going to go right back to what he's doing. It's nice to have a drug program and it's nice to have rehabilitation, but it's never worked on this person or Kim Higbee or Jimmy Aikman or Bert Evans. I'm not being really benevolent with this outlook, but this isn't the first time. This is the worst time. This is the most damage that's been done to me. And I'm 63. I'll be 63 tomorrow. I don't have it in me. I buy and sell school buses for a living. I have some rental properties. I don't really have it in me to easily make back that kind of money that was taken from me. You know, dealing in school buses is a lot of physical work. I just don't have that in me. So what they've taken from me is going to be very hard for me to be able to replace. And I'd like you to please sentence this guy. For one thing, he needs to make payment on restitution. SSI, you know, he gets out. He's got to pay something. I mean, I'd like him to pay $1,000 a month every month for the next couple of years. There's even more to it, but I can't go on and on about everything that they've done. I mean, the keys alone, they took the keys. We actually found a couple of keys laying in the grass outside when we were picking up limbs. So I don't know why they took all the keys. Well, obviously probably to come back and try to steal the vehicles later, but the keys are gone. And this happened in a 3-day period. It wasn't like it was, you know, a month later and a month later. It was this 3-day period. They got the keys. They got access to and they cut the locks on the gym. I sent a list of the items that were stolen, and the deputy Myers went through the building on the phone with me, and the neighbors were there, and I was asking them, and I was saying, look for the zero-turn lawnmower, that's gone. What about the push behind? That's gone. What about this? That's gone. And they walked through the buildings, and they could see, in addition to that, in the boiler room, when I finally got back there, in the boiler room, I could see where somebody had set a trap with a piece of wire and a sharp piece of metal and a rod, where if you walked through that door, the metal would fall on you. So what are these people doing? I mean, was that trap for me? So that's my statement.
All right, thank you, Mr. Hanson. All right, Mr.
The
Chief.
total amount is $25,821. I don't have a printer here. I'm in Minnesota working right now, and I don't have a printer to print this off. Sorry.
There was some documentation presented as part of the PSI the victim impact statement that she did submit that I did have an opportunity to review prior to today. All right, Mr. Cheever, is there anything that you would like to say before the court pronounces sentence?
Yeah, there's a lot of things I'd like to say, but Mr. Henson's wrong. I was just giving somebody a
All right, miss, I can't hear you, Mr. Cheever.
Yeah, there's a lot of things I'd like to say. Mr. Henson's wrong. I was just giving somebody a ride. I took this plea because of restitution involved. That's about all I got to say. I ain't stepped foot on that jail, school in 50 years. Not since I graduated to sixth grade. I am. One of the reasons he got his boat motor back is because I accidentally found out where it was. I didn't take the motor. I believe Mr. Evans told me it belonged to Miss Whitaker. That's where I dropped him off at. I went around the block to pick him back up because he said it was too hot to work at Mrs. Whitaker's. That's where he was working at. I didn't have anything to do with stealing anything from Mr. Hanson. I got his boat motor returned to him. That's about all. I'm not guilty of stealing anything from this man.
Can I say one more thing?
No. All right. Anything further, Mr. Cheever?
No, that's it.
All right. Mr. Cheever, for the primary offense of theft, a level 9 non-person felony with your criminal history score of C, I do sentence you to the standard term of 12 months with the Department of Corrections. You are eligible for 20% good time credit and are subject to 12 months post-release supervision. This is a case that is presumptive probation and has been scored for mandatory Senate Bill 123 drug treatment. Therefore, by statute, you will be placed on probation for a period of up to 18 months with community corrections. You will be ordered to follow all standard conditions of probation, including completing Senate Bill 123 treatment. You will be ordered not to possess or consume alcohol or illegal drugs. You will be subject to random breath, blood, and urinalysis testing. You need to follow any community service work hours that are part of the community corrections program. You need to notify your probation officer of any changes of employment, address, phone number, email address. You're not to violate the law. If you have contact with law enforcement, you need to let your probation officer know within 48 hours. You're to have no contact with the victim, Daniel Hanson, or any of his property. You're to have no contact with the co-defendants in the case. If you haven't already submitted a sample of your DNA to the KBI database, you will be ordered to do so and to pay the fee associated with that. You're ordered to follow all curfew and travel restrictions that are set forth in the probation program. You're ordered to participate in the MRT program and comply with all of your Senate Bill 123 treatment recommendations. I'm going to order you pay the court costs in the case as well as the probation supervision fees. I'm going to order that you pay the Senate Bill 123 assessment fee of $175, as well as the Senate Bill 123 offender reimbursement fee of $125. I'm going to order you pay a $45 booking fee. In order that this case run consecutive to Elk County case 22 CR 62. A restitution figure has not been submitted by the state, so none will be ordered. I am going to order you pay the bids, reimbursement fee. Mr. Cheever, what is your employment or disability status?
I'm on disability. I'm on
How,
disability, Your Honor,
and how long have you been on disability?
about 4 years.
Do you have any other sources of income?
No,
Do you have dependents that you support financially?
no,
Or I'm going to order that you pay $250 towards court-appointed attorney's fees. You may have a right to, I'm going to order you pay a minimum of $50 a month towards your costs and fees. First $50 payment will be due by the last business day of December and by the last business day of each month until paid in full. You may have a right to expunge this conviction from your record at some point in the future. You do have a right to appeal this sentence. If you choose to appeal, you have 14 days from today's date. If you can't afford an attorney to do an appeal, one would be appointed for you. As a convicted felon, you're not to possess firearms, and there are the loss of certain civil rights, such as the right to vote, until your sentence has been fully discharged. Mr. Lett, are there any sentencing related recommendations that I have failed to address?
You said expungement, right?
I did.
I can't think of anything else.
Mr. Ambrose, can you think of any sentencing related orders I failed to address?
Nothing sentencing related, Judge, but if you could toss me in if Ms. Cool could toss me in a breakout room with him real quick so I could give him some final instructions before we're done this morning after the court finishes, I'd appreciate it.
All right, Miss Ashenfelter, do you need to meet with him in a breakout room, have him call you?
Your Honor, if I could get a breakout room after the hearing.
All right, Mr. Ambrose, do you wish to visit with him before he visits with Miss Ashenfelter?
I'll just go on with Miss Ashenfelter and we can take care of it, and then she can talk with him, then I can speak with him when she's done with him.
All right, Mr. Cheever, you've got a year in prison hanging over your head. Violations of probation will get you right back in front of the court with the possibility of being ordered to serve that underlying sentence.
Your Honor.
Do you have any questions about the sentence that's been imposed? I couldn't hear
no,
that.
Your Honor.
All right. Was somebody else wishing to address?
Your
the
Honor,
court?
yes.
Mr. Bauer?
On the DNA fee, I know you said if it has not been done to do that, his prior felony was in the 90s. It was prior to the DNA database and stuff. According to the records check I ran on him, it was not on file at the time I did that. So I believe he needs to do the DNA. And then the assessment for that, the fee for that should be assessed since his prior felony was prior to that DNA being imposed in Kansas.
All right. You will be ordered to pay the $200 DNA fee, Mr. Cheever.
That's fine, Your Honor.
All right. Mr. Hanson?
What about restitution?
The state did not submit a restitution request as part of the sentencing recommendations.
But don't I have a right to request it as a victim?
You'll need to address those concerns with the county attorney's office. I can only order what's been brought before me as recommendations from the state.
So is he going to prison or is he just on probation now?
He was ordered to probation.
So he doesn't do any prison time.
It's a presumptive probation case, Mr. Hanson. So
$25,000 and he gets probation?
all right. If there's nothing further, then we'll be in recess on the Cheever matter.
Next case, State of Kansas versus Richard Robert Crumrine, 25 CR 516. Good afternoon, Mr. Crumrine.
Afternoon.
Mr. Crumrine, you have been charged by way of information, count 1 on or about November 25, 2025 in Butler County, Kansas with possession of methamphetamine with intent to distribute, a level 3 drug felony. Count 2, you're charged, same date and location, possession of methamphetamine, a level 5 drug felony. Count 3, same date and location, possession of paraphernalia to distribute or manufacture, a level 5 drug felony. And count 4, same date and location, possession of marijuana, class B, non-person misdemeanor. Count 5, same date and location, possession of paraphernalia for use, a class B, non-person misdemeanor. Count 6, same date and location, failure to maintain a single lane and infraction. And Mr. Crumrine, those are the charges pending against you. Do you understand the charges?
Yes, I understand them.
You do have the right to counsel. If you cannot afford an attorney, one would be appointed to represent you. And court makes inquiry. Are you currently employed?
I'm probably not now. I just supposed to start a new job work for Greg Greer sandblasting. I'm supposed to start this morning.
And do you have money saved up to hire an attorney?
No, sir. I'm actually in the middle of a divorce.
Based on your lack of financial wherewithal, the court does order counsel appointed to represent you. Court orders Jim Watts to represent you at all stages of the proceedings. Jim Watts is appointed to represent you at all stages of the proceedings. The court sets your case next before Chief Judge Rickey on the felony preliminary hearing control docket. That would be December 29, 2025 at 2:30. Monday, December 29, 2025, 2:30 by Zoom. That would be by Zoom before the Chief Judge Rickey. Subsequently, the court now needs to set appropriate bond. Mr. Crumrine, what is your current address?
602 Southeast Poor Farm Road.
How long have you reside? Yes, sir. How long have you resided there?
Probably about 6 months, 5 months.
Do you have any family that reside in Butler County, Kansas?
Yes, I do. My sisters.
And their names and addresses?
One of them, I don't know the exact address. One of them's on Waco Trailer Park here in El Dorado on 6th, and the other one's on South Emporia in El Dorado.
And their names?
Michelle Warner and Amanda Crumrine.
Thank you, Mr. Crumrine. Recommendation for bond from the state, Mr. Regier.
Your Honor, in this matter, the state is seeking a high bond at a very minimum of $15,000 cash or surety. The state's information is this is a defendant who has failed to appear for court at least 15 times in the past, so the state does consider this defendant a significant flight risk. It would appear that this is a defendant who has at least 3 other Butler County cases currently before multiple courts. 25 CR 068, the state's information is that is currently set for jury trial in February of next year. 25 CR 289, the state's information is that is currently set for preliminary control on December 8th of this year and involves the same or similar charges as the current case. 25 TR 2375, the state's understanding is that case is currently set for hearing in January of 2026. Additionally, the information in counts 1 through 6 appear to allege an occurrence date of November 25th of 2025, approximately 1 to 2 weeks after the most recent hearing in Butler County 25 CR 289. The state's information is that matter last came before this court on November 14th. Additionally, this is a defendant with a history of prior convictions that the state considers relevant. Besides at least 1 prior conviction for misdemeanor possession of simulated controlled substance, at least 1 driver's license violation and driving while suspended, at least 5 non-drug and non-traffic felony convictions. So the state does respectfully submit, with all that being said, that a $15,000 cash or surety bond at the minimum is appropriate.
Thank you, Mr. Regier and Mr. Crumrine.
I was just driving my truck. I was taking a girl a ride. I don't even know what happened to her. They took her home last night, and it was everything was found on her side of the truck. And I took her to go get Christmas presents for a kid. Thank you, Mr. Crumrine. The main concern the court has is the number of failures to appear previously before the court. Yeah, I talked to you last time. I think I talked to you last night. I had court. I had filed the motion to have all my, because I had so many dates going on with stuff, and because with my divorce stuff and all this, all my dates were getting mixed up. And I had filed the motion. I got a hold of my attorney James Watts about getting everything brought together. So I didn't have so many court dates to mix, and I never heard nothing back. I wrote him a letter and everything. That's why I missed court soon. It's because all my court stuff. I had too many dates. I couldn't remember it all. Thank you, Mr. Crumrine. Mr. Crumrine, I do believe that the recommendation that the state has made to the court of $15,000 cash or surety bond is appropriate. The court does find that to be an appropriate bond subject to the conditions therein. So the court does set your bond at the amount of $15,000 cash or surety bond. Anything further, Mr. Regier?
No, Your Honor.
Anything further, Mr. Crumrine? No. There being nothing further to come before the court, court is in recess. Mr. Crumrine, have a good day. Yes, sir. Next case, State of Kansas versus Patrick Kelly Waring, 24 CR 233. Good afternoon, Mr. Waring. You're back before the court after apparently failing to appear on October 21, 2022. Subsequently, the court finds that this matter still needs to come before the court apparently for sentencing, and it has not. The only date that I have that would be appropriate, it would appear, would be on the felony preliminary hearing control docket of Monday, January 12, 2026 at 2:30. And Judge Satterfield has ordered a no bond hold on you. Judge Satterfield has ordered a no bond hold in regards to yourself. And that was for failure to appear at the sentencing date, which was set back on June 24, 2025. All right, so you've got a no bond hold by Judge Satterfield. Your next date, I'll put it for the felony preliminary hearing control docket before Judge Satterfield on January 12, 2026 at 2:30. Monday, January 12, 2026, 2:30 before Judge Satterfield.
All right, that's for sentencing?
Yes.
Okay.
Anything further, Mr. Regier?
I'm sorry?
I was speaking to Mr. Regier, the prosecutor on the case.
Your Honor, the state's information is that as recently as a hearing in October of this year, although the defendant did not appear at that setting, Attorney Joseph Favre did appear based off the state's information. The state would be requesting clarification as to whether or not the court still considers him counsel of record in this matter. The order appointing private counsel or public defender back in May of 2024 appears to specifically refer to Mr. Watts.
Well, I'm trying to read through Judge Satterfield's notes, and I'm not able to decipher the notes in regards to the question that's been asked as to whether it's Mr. Watts or Mr. Favre. I do not know. It would appear that Mr. Watts was appointed on January 13, 2025. Mr. Watts was appointed, but oftentimes Mr. Watts will assign certain appointed cases to Mr. Favre. I do show that on April 7, 2025, that Mr. Favre was appearing So it would appear to myself that Mr. Favre is the attorney of record for Mr. Waring.
Thank you, Your Honor.
There being anything further, Mr. Waring?
What, I'm sorry?
Anything further?
I just, I had a hard, I had a hard time. I lost everything when I was first arrested. My truck, all my tools was stolen. My life was wiped upside down by the act of another woman. I did not do what this was all is. I'm gonna accept for what I've done at this point in the sense of I failed to appear, but it's not purposely. I say that honestly, it wasn't purposely. I've been left homeless, without work, a phone, and I just started working with my brother that just moved back to Wichita. So I'm trying to fix my life at this point. So that's really all I've got right now. I'm just really looking forward to getting my life back together. I finally have a decent opportunity to do that. And being here is part of it, honestly.
There being nothing further to come before the court is in recess, and have a good day, Mr. Waring.
All right, thank you.
Next case, State of Kansas versus Justin D. Jones, 25 TR 879. Good afternoon, Mr. Jones.
Afternoon.
You are present back before the court off of the failure to appear, and that was from October 29, 2025. October 29, 2025, when you failed to appear. The court sets this back before the court on the expedited docket, and that is set before Judge Lee on Friday, December 5, 2025 at 1:30. On the expedited misdemeanor control docket, Friday, December 5, 2025, 1:30. Before Judge Lee, you do need to be present at that time. And there has previously been a bond forfeiture bench warrant with a no bond hold placed on yourself by Judge Webster. And anything further, Mr. Regier?
Your Honor, 2 points, if I may.
Yes.
Your Honor, this is a case where it would appear there were two consecutive failures to appear on July 16th and October 29th. The state's information is as a full first appearance hearing has not yet been conducted in this matter. I'm not sure if the court wishes to address that issue at this time, nor is the state aware of nor does the state take a position as to whether or not the court wishes to address the issue of counsel of record, if any, at this time.
Thank you, Mr. Regier, and the court does concur, and thank you, Mr. Regier, for bringing that to the court's attention in regards to no first appearance. Mr. Jones, in case number 2025 TR 879, you are charged by way of information on or about February 4, 2025 in Butler County, Kansas, with driving while license is suspended or canceled, a Class A non-person misdemeanor. That is the only charge pending against you. And do you understand the charge?
I do.
You do have the right to counsel. If you cannot afford an attorney, one would be appointed to represent you. Are you currently employed?
I am.
Where do you work?
I actually subcontract for a small electrical repair shop in West Wichita.
And do you have any money saved back to hire an attorney?
I do not. As a matter of fact, right now, I don't know if I'm currently employed any longer or not.
Based on your lack of financial wherewithal, the court does appoint counsel to represent you. The court appoints Darren Patterson to represent you at all stages of the proceedings. Darren Patterson is appointed to represent you at all stages of the proceedings. All right, now the court goes back, and with all that being said, we've got counsel appointed, and I needed to, since there's been no appearance before the court, it does not appear appropriate to the court to order a no bond hold on Mr. Jones. I think a appropriate cash or surety bond would be appropriate in this situation? And recommendations, Mr. Regier.
Your Honor, may I request a brief 2-minute recess to review certain matters, at which time I will be prepared to make appropriate recommendations.
Yes, thank you, Mr. Regier.
Thank you, Your Honor.
And recommendations, Mr. Regier.
Your Honor, if the court is prepared to modify the previously ordered bond in this case, the state would be recommending a high bond in this case. In this particular matter, it would appear that previously a bond had been executed in the amount of $2,500 professional surety, but the same had been insignificant to secure the defendant's appearance at the October 29th setting, which does appear to be the setting with which the bond was specifically executed for. This is a defendant who the state understands has a history of prior convictions that the court may consider relevant. Besides at least 1 vehicle registration violation, 2 prior convictions for no valid driver's license, 3 prior driving while suspended, and 1 DUI. The state would be recommending at the very least a $10,000 cash or surety bond in this case. Additionally, not to muddle the waters further, there appears to be another Butler County case involving this same defendant, 24 TR 3028. That same matter does appear to be before Judge Webster's court on December 1st at 9. I am not sure if the court wishes to take up that matter as well in the interests of judicial economy. If so, what I would tell the court is that in addition to the 2 failures to appear in the case actually on the dock today, there appear to be an additional 2 failures to appear in that case as well. And the state is not aware of any entries of appearance or orders appointing counsel in that matter.
What is the date again that Mr. Jones is to appear before Judge Webster?
Based off state's information, Your Honor, 24 TR 3028 appears to be currently scheduled for December 1st at 9.
Okay. It would appear to myself that that's an appropriate date to set this over to, so both cases can be taken up at the same time. So that is set over to December 1st, 2025 at 9 a.m. by Zoom. 9 a.m. by Zoom. Is Mr. Patterson appointed on that 24 TR case?
Your Honor, as previously indicated, the state is not aware of any formal entries of appearances or orders appointing counsel in the 2024 case.
Okay. The court does appoint counsel to represent Mr. Jones in 25 TR 879. That would be Mr. Patterson. I am not going to set these on the same date. The court retracts setting the cases on the same date because that's coming up this Monday. So the court does set this matter over before Judge Webster on Monday, February 9, 2026 at 8 a.m. The court does appoint Mr. Patterson to represent Mr. Jones at that time. Anything further? The court does order 10,000 cash or surety bond as recommended by Mr. Regier.
May I ask a question?
Yes.
Is there any way to lower that bond if I was to say go on house arrest until this court date so I can keep going to work? If I'm stuck in this jail until in February, there is absolutely a 100% guarantee that I am not able to maintain my financial obligations outside of this.
Thank you, Mr.
I would be absolutely willing to wear a monitor 24/7 until the court decides otherwise if I can go to work.
Thank you, Mr. Jones. State's position on electronic monitoring of Mr. Jones.
One moment, Your Honor.
Your Honor, what was that February court date?
It's February 9, 2026 at 8 a.m. Monday, February 9, 2026 at 8 a.m.
That was for 24 TR 3028.
That's for 25 TR 879. 25 TR 879. Mr. Regier noted an appearance is due by Mr. Jones this coming Monday, December 1st. Monday, December 1st, he's on the docket before Judge Webster.
Thank you.
Your Honor, pursuant to the information filed with the court in the 2024 case on November 18th, that information would appear to allege 3 counts, all alleged to have occurred on August 15th of 2024, involving at least 1 unclassified misdemeanor and 2 Class B misdemeanors. The information in the current case appears to allege a subsequent occurrence date on February 4th of 2025. With all that being said, if the court is prepared to order GPS monitoring, the state would be prepared to amend its earlier recommendation to an $8,000 cash or surety bond based off of the history of these cases. The state does consider this defendant to be a very significant flight risk.
Thank you, Mr. Regier. Mr. Jones, the court orders $5,000 cash or surety bond with electronic monitoring. 5,000 cash or surety bond, electronic monitoring. And you've got a court date coming up on Monday. And then you've got this case, 25 TR 879, coming up on Monday, February 9, 2026 at 8 a.m. before Judge Webster. That case, the court appoints Darren Patterson to represent you.
Okay.
There being nothing further to come before the court is in recess. Have a good day.
Good morning. What is your name, please?
Natalia Baptiste.
All right. Thank you, Ms. Baptiste. And there are 2 matters that are before the court, 23L001529 for a review hearing of a compliance with a stipulated order of continuance agreement, as well as 24L000170 that is before the court for a 3rd pretrial conference. Ms. Capone, it does appear that your office represents Ms. Baptiste in each of these 2 matters. How would you like to proceed with the pretrial conference?
Your Honor, on the pretrial conference, we're asking the court to release Ms. Baptiste on her own recognizance. She is before the court on a warrant return, and I do have some information to share with the court. As to that review matter, I don't know that there is an agreement to preserve the stipulated order of continuance, given that there's been conviction since. So if the court would like to take up revocation of that today, I wouldn't have an objection to that. But we are asking that Ms. Baptiste be released on her own recognizance. I will let the court know that she just got released from Lewis County Jail after doing a 4-month sentence just this past Wednesday. She reached out to the court from the jail trying to get a quash hearing set and take care of this matter, and just was unlucky and got picked up on this warrant just the other day here. She, after serving those 4 months, is trying to get her life back on track. She had a job that she obviously wasn't able to participate in while incarcerated, but has indicated that she can get that job back. She wants to re-engage in the community. She has appointments lined up. She also has 4 children to take care of. They're ages 18, 14, 9, and 7. She indicated she originally missed that court date that resulted in the warrant because her attorney had indicated that she did not need to be there. I understand that the court has maybe heard this before, but I think that this is persuasive because this is a toxicology case. And I could foresee a situation in which perhaps an attorney thought that the case was being dismissed pending talks, and then maybe it wasn't. I understand it was Ms. Baptiste's responsibility to follow up on that, but I do think that that is a plausible explanation as to at least why she had some confusion. I'd also point out that she has no violent history. She has no similar history to the DUI offense charge, and no new history consistent with anything similar to a DUI charged here since
She does have some warrant history, but I point out that 88% of those warrants are from 2019 and older. So I do believe that Ms. Baptiste has a good record as to where she's been during this time and has a lot of community ties and reasons to appear for court going forward. I think that she would be able to best assist her counsel and make decisions if she was released from custody. And for all of those reasons, we're asking that the court do so.
Thank you, Ms. Capone. Mr. Graham, what is your position concerning the request for personal recognizance release under case number ending in 0170?
Yes, Your Honor. The city is opposed to release on personal recognizance in this case. Ms. Baptiste has a long history of warrants. While on the supervision of this court, at least as to pretrial release, has since been convicted of burglary in the second degree and retail theft special circumstances in the second degree, which is the time that Ms. Capone was referencing that she just completed serving. Your Honor, we haven't seen Ms. Baptiste in this case, even through counsel, since I believe it was April of 2024. So we have not seen her for going on over a year and a half. And so I do think bail is appropriate since the lack of bail, she was incapable of appearing before this court under her own power. On top of that, continuing to violate the conditions of release by this court. City would recommend that she be held on $5,000 cash or bond at this time.
Thank you, Mr. Graham. And Mr. Graham, what is the prosecution's position concerning the record that's been made by the defense on the stipulated order of continuance matter, case number ending in 1529? Is the city asking the court to take any action today?
Your Honor, she has violated the nature of those of that SOC. The city would move to revoke the SOC.
All right. So first things first, let's go ahead and address case number ending in 1529 based on the subsequent law-abiding behavior violations, the convictions that were mentioned by Ms. Capone out of Lewis County Superior Court, which were entered obviously after the court entered into the stipulated or allowed entry of the stipulated order of continuance agreement. Ms. Capone, did I understand the record that you were making correctly that the defense is stipulating to that violation of the stipulated order of continuance agreement?
On those subsequent convictions, yes, Your Honor.
All right. Based upon that, the court is going to grant the prosecution's motion to revoke the stipulated order of continuance agreement that was entered into by the parties in case 23L001529. The court, pursuant to the terms and conditions of that stipulated order of continuance agreement, will go ahead now and review the exhibit that was admitted by the parties as the sole evidentiary basis for the court to consider at a bench trial on the charge of theft in the third degree to determine whether or not Ms. Baptiste is guilty or not guilty of the crime of theft in the third degree as charged in that case. Give me one moment while I pull up that exhibit, please. Court has reviewed the report of Officer Daniel Tenney of the Lakewood Police Department, signed under penalty of perjury on October 19th, 2023, is filed as the stipulated exhibit in case number ending in 1529. Based upon the facts that have been stipulated to in that report, the court does find that there are facts sufficient to find beyond a reasonable doubt that Ms. Baptiste is guilty of the crime of theft in the third degree. The court will return a verdict of guilty at this time. Mr. Graham, what is the prosecution's recommendation as to sentencing in case ending in 1529?
Yes, Your Honor. Your Honor, a review of Ms. Baptiste's criminal history. I do believe I counted 5 prior convictions for theft-related crimes dating all the way back to 2003 to as recent as August of 2025. Ms. Baptiste continues to take what is not hers from the community. The recommendation from the city, Your Honor, would be 15 days and close the case.
Ms. Capone?
Your Honor, we'd be asking that the court give Ms. Baptiste 3 days credit for time served and close out the matter. It seems she had a day credit from when she was originally booked and then from now. So I'm calculating 3 days. This court already has her on conditions of release for the pretrial driving under the influence. The court is aware that Ms. Baptiste is indicating that she served 4 months just recently and has not been out of custody. She was moved over here and is continuing to remain in custody. I understand that she didn't receive credit from this court because she wasn't held. But I asked the court to recognize that, give her credit for the 3 days that she served and close the matter out.
Thank you. Ms. Baptiste, you have the right to make a statement to the court before the court imposes sentence in this matter. You don't have to say anything. I'm not going to hold it against you if you choose not to make a statement, but you do have that right. Is there anything you would like to tell the court before I impose sentence in case number ending in 1529 on the charge of theft in the 3rd degree from October 19th, 2023?
I understand I did purchase some of the items. One item wasn't rung up at the time, sir, so it wasn't that I was stealing anything. And I would love to get a chance to get these 3 days out the way so I can move on with my life and continue to do for my kids and go back to work and school. This is the second time I have to be enrolled back into school, and I would love to get that chance so I can be out and start that pretty soon. I squashed all my other warrants in Tacoma. I took 12 days for that, and I'll be released on the 6th. So I'll be happy if I can actually walk out of here on the 6th. And bail, I don't have money for a bail for the other charge at all. I don't have anything. I don't have anybody that can post my bill.
All right. Ms. Baptiste, I appreciate that. And I would love to see you further your education and complete that process. I look at your criminal history and you're obviously a very intelligent, capable person. You know, I don't see any need for the criminal history that I see here. And I'd love to see you turn that chapter of your life and move past that and put all of this behind you. That said, I also cannot ignore the criminal history that is present before the court, including specifically the prior convictions for theft. But the court is also mindful of the fact that in this particular case, based upon the court's review of the stipulated exhibit, I think the monetary amount that was at issue in the theft was approximately $17 from the Safeway store here in the city of Lakewood. And so it's certainly not a significant amount of property that was being taken. Nonetheless, it is a crime of theft in the 3rd degree. So the court's going to kind of split the difference here. The court is going to impose 10 days in jail on this matter. I will give, are the parties in agreement that under case number ending in 1529, Ms. Baptiste is entitled to 3 days credit? I did hear Ms. Capone say that, but I want to make sure Mr. Graham had the opportunity to weigh in on that calculation.
Your Honor, I'm just going to double check real quick.
Thank you. Court is also going to adopt what appears to be an agreed recommendation from the attorneys that once those 10 days are served, that this matter will close. The court will not suspend any portion of the sentence, will not take any additional jurisdiction, and will not impose any additional conditions of sentence.
I agree with the calculation, Your Honor.
Thank you. So the court will impose 10 days in custody, credit for 3 days that are served. Court has signed that judgment and sentence. All right. And that now takes us back to where we started, which was the pretrial conference matter under case number ending in 0170. I do see that the document indicates that there is a bond that was previously posted. Does either attorney know what that bond amount was or is?
I believe it was $3,000, Your Honor, and I only say that by it's very odd the docketing for when the warrant was issued, because it looks like the court issued a warrant in the amount of $4,000, but then the total warrant amount became $7,000 because the bond was forfeited.
Okay. All right. So there is no bond in this case at this time. All right. So the court is concerned in this particular case with the warrant history that Ms. Batiste presents with. I think the most troubling thing that I've heard from the attorneys is, and Mr. Grant, you can correct me if I'm wrong, but or Ms. Capone can correct me. What I heard was the parties indicating that the last time Ms. Batiste was before this court was April of 2024, and the court has not seen Ms. Batiste since, and she's been on warrant status, I believe, since April or May of last year, if I understood the record that was being made by the attorneys correctly. That is concerning to the court that approximately a year and a half has gone by. I understand that Ms. Batiste was in custody for a significant portion of that in Lewis County, but the court cannot ignore the fact that this case, the incident date is January 31st, 2024. So we are very quickly coming up on this case being 2 years old from date of incident. The court does believe some bail is appropriate, so the court is going to impose bail in the amount of $1,000 cash or bond at this time. All other previously imposed pretrial conditions will remain in full force and effect. By way of review, I'm just going to go ahead and go over some of those conditions at this point in time. Ms. Batiste, if you are released from custody, you are ordered to appear in person and on time for all scheduled court hearings. You are to have no criminal law violations. Update the court of any change in your mailing address. You may not drive a motor vehicle without a valid driver's license and proof of insurance. You may not drive or be in physical control of a motor vehicle after having consumed any alcohol, marijuana, or impairing drug. You may not refuse a request for a breath test or blood test upon the request for such a test by a law enforcement officer. You may not use or possess any alcohol, non-prescribed drugs, marijuana, or drug paraphernalia while this matter is pending. And you are to comply with any requirements concerning the use or equipment on any vehicle of a functioning ignition interlock device if that condition is imposed by the Washington State Department of Licensing. Ms. Capone, given that the court has set bail in the amount of $1,000 cash or bond, are you requesting an in-custody pretrial conference date?
Yes, Your Honor. We'd be asking for as soon as possible. I believe that would be Wednesday.
Yeah, and let me just confirm that. Okay, yeah, I am being told that we do have a calendar and Squally calendar that day, so we will go ahead and set that for Wednesday, December 3rd. And I believe that is at 11 a.m.
Your Honor, Is that the date that I believe the court was, or at least court administrator sent out that those were being, it was being fairly limited? Am I misremembering?
That's why I was asking the court clerk. I know that the Pierce County Jail calendar is not being held that morning at 10 a.m. My question was whether or not we have a calendar at 11 a.m. and I'm being told that we do.
I see, Your Honor.
Okay. All right. So we'll just go, yeah, we'll just go ahead and set this for Wednesday, December 3rd at 11 a.m. And I'm sorry, O Court's just closed on me, so I have to complete that order again.
Since Ms. Capone was looking for a sooner date, Your Honor, I wouldn't object to December 1st.
Yeah, I'm being told that we are only setting arraignments on that matter or on that calendar. Okay, and the court has signed. Well, actually, let me add one other thing. So I'm also going to add an out of custody pretrial conference date in this matter. That'll be set for January 13th, 2026 at 1 p.m. in the event that Ms. Batiste is out of custody in this matter prior to her next hearing in this matter.
So my next hearing's the next Wednesday.
Yes, if you're still in custody, your next hearing will be on Wednesday at 11 a.m. from the Nisqually Jail. If you're out of custody between now and then, your next hearing will be January 13th, 2026 at 1 p.m. here at the Lakewood Municipal Court.
But I'm about to be serving time on the other one, so I will be here.
Okay.
And Your Honor, before the court excuses Ms. Baptiste, I just want to take up one last thing.
Certainly. Okay, Ms. Capone.
Your Honor, I'm just asking the court to make a formal record as to a reappointment of counsel given the passage of time. As I previously stated, she's been incarcerated, so has not had any income, supports 4 children. I can certainly submit to the court a screening form, but we just ask that the reappointment be made.
Court will reappoint the Horwath law offices in this matter.
Thank you.
Thank you. Court has signed that order. Ms. Batiste, that will conclude your hearing for this morning. You can go ahead and let the officer know that your hearing is done. Thank you.
How can I talk to Miss Patty again? I can't.
You can give her a call after the conclusion of this morning's calendar. Give her a call at her office.
I don't have her. How would I be able to get her number?
Would the court entertain me providing our office's number?
You can go ahead, Ms. Capone, if you want to provide her with a number.
Ms. Baptiste, do you have a way to take down this number?
No, I don't.
I will tell you, Ms. Batiste, I think that the officers there do have the number for Horwath law offices. I will also tell you that it will appear on your paperwork that I just signed. So when the officers give you a copy of your paperwork, the telephone number will appear on that order.
And I can talk to her?
Yes. Yeah. If you give her a call after she finishes the calendar, she should be available.
Okay, what time will that be? Do you know? So I can just know.
I suspect we should be done with the calendar by 12:30.
Okay.
I can't speak to Ms. Capone's availability, but we should be done with this calendar by 12:30.
Okay, thank you.
Thank you. Sir, good afternoon in the Nisqually Jail. What is your name, please?
Stephen Myers.
Thank you. Mr. Myers, I show that your date of birth is March 8th, 1983. Is that correct?
That is correct.
All right. And this matter is before the court for a review hearing, case number 14L000657. This is quite an old case. Mr. Myers, it appears, was last before the court. Let's see here. It appears it was way back in 2015, on December 24th, 2015. That time the court found a violation for failure to comply with an alcohol evaluation and completion of alcohol drug information school. Court imposed 45 days at that point in time. It appears that the sanction was of 45 days was authorized to be served via electronic home monitoring, if I'm reading the calendar correctly. It appears that a electronic home monitoring appointment was scheduled for January 21st, 2016 at 1 p.m. And there's a docket entry that Mr. Myers failed to appear for that electronic home monitoring screening. A bench warrant was issued at that time. On January 26, 2016, the bench warrant was ordered. And it appears that that warrant has been outstanding ever since. It appears that not only was the warrant for the failure to comply with the EHN outstanding, but it appears that there are still outstanding issues concerning compliance with affirmative conditions of suspended sentence, including completion of a chemical dependency evaluation from a state certified agency and filing a copy of that evaluation. And it appears that there is also a new, or I shouldn't say new, but a subsequent pending charge out of Pierce County District Court for a charge of, no, I don't think that was subsequent. Okay, so yeah, it just looks like it's the EHM and the lack of compliance with affirmative conditions. Mr. Grant, what is the prosecution's position?
Yes, Your Honor. Your Honor, I was looking back through this docket and then I realized that my name was found in it, dating back into the, when he was originally convicted, back in 2014. I do agree that he currently owes 45 days. Recommendation from the city, Your Honor, is to have him serve those 45 days and close the matter.
Ms. Capone?
Your Honor, Mr. Myers is asking for the opportunity to do this on electrical monitoring. I understand, given the passage of time, where the court might stand regarding this, but he indicates that he does have a home, and he does have employment, a place that he's been employed for the last 9 years. He indicates that if he were to stay in custody, he will lose that job. He also supports 3 children. So he's asking for an opportunity to serve this on electrical monitoring. And regardless of how the court approaches this, I will ask that he get credit for 4 days served as of today. But Mr. Myers' request would be to be able to serve this on electrical monitoring. We would join in the request as well to have this matter close out when the time is served.
Thank you. The court is going to go ahead and, well, and I don't even know if reimpose is the right word. Judge Lindstrom imposed that 45 days in custody, afforded Mr. Myers the opportunity to serve those 40 days on EHM, but obviously that did not occur. So the court is going to go ahead and order that those 45 days be served at this point. Mr. Myers will be receiving credit for the 4 days that he has already served since the execution or the service of the warrant that was issued back in 2016. Once those 45 days with credit for 4 days are served, this matter will close at that time. And the court has signed that order. Mr. Myers, thank you, sir. That will conclude your hearing. You can go ahead and let the officer know that your hearing is done. Thank you.